Welcome back to Federal Gaming Law. I guess we can get started. Again, because the class has about a third of the students have never had a gaming law class before, we're going to go over some of the basics. Now, for those of you that took the technology class, this is going to seem like a repeat, and probably about 80% of it or more is. So, great refresher if you want to stick around. If you don't, I completely understand. But again, we're going to kind of go over the basics again so that everybody has a common understanding, including the third of the class that has never had a gaming law course before. So a bit of overlap for those who have taken a class with me before. Just a kind of quick recap. This is my contact information.
May I put?
Again, final exam is the primary part of the grade. For classes that I teach, I will post the video of the class, or at least for Zoom-based classes that I teach. However, guest speakers may not permit recording, so there may be some classes that don't make it up to the site. And that's generally because there's a restriction imposed by the guest speaker. There is one other instance where the recording won't be posted, even if I do it, and that's if Zoom screws up, which has happened a couple of times, where I'll download the Zoom video only to find out that it's just garbage. It's garbled. You can't make out any video and you can't make out any audio. So that does happen from time to time. But anyway, these classes will be online if I'm teaching them, for the most part. So let's start with the background. Again, for those of you that have never taken a gaming law class, you know what's gambling? What do you think gambling is? If you've never taken one of these classes before, Courtney.
A game of chance with like money or some other thing of value involved.
Yeah. Games of chance. That's a common form of common phrase we hear with gambling. Another way to we see it expressed is usually it's the opportunity to win something of value based on the outcome of an event that you don't control. Something like that. It gets described different ways in different statutes and different regulations, different court opinions. But you kind of get, that's kind of the gist. For those, again, that haven't taken a gaming law course before, what are some different types of gambling or gambling games? I know it's early. Well, you have things like lotteries. Lotteries gambling. See the story this morning? Someone in Michigan won $3 million, and she didn't find out until she was cleaning out her spam folder. Thought it was spam until she checked her online lottery account in Michigan and found out she won $3 million. That's definitely gambling. She paid a few bucks for a ticket and ended up being drawn as the winner. The games of chance, Courtney, you mentioned that. Sports wagering, generally considered gambling, right? Pari-mutuel wagering, horse races, dog races, highlight. Bookmaking, sort of the flip side of that, the bookmaking is generally deemed to be gambling. So you have different activities, different things that often get identified as gambling. So let's talk about some of the differences here. One key difference to keep in mind as you're going through statutes, if you're ever doing research on gaming, is to distinguish lotteries from games of chance. So in a lottery, how much influence do you have over the outcome of the event?
None.
Anybody? None. Yeah. What about blackjack? Blackjack, you think, is that everybody familiar with blackjack? Anybody not familiar with blackjack? That's okay if you're not. Just let me know. I'll explain it. Okay, so everybody's familiar with blackjack. Do you have any control over the outcome of blackjack? Yeah. You guys see a lot of people nodding their heads. Okay. Blackjack's still a gambling game? Yeah. That's kind of the difference. So lotteries are usually based purely on chance. Games of chance, not necessarily purely chance. And why is this distinction important? Well, because the United States, we have a lot of state statutes, or state constitutions that will prohibit or permit a legislature to enact a form of lottery. So, for example, there's a state in the Midwest that in the state constitution, it was changed to allow the legislature to enact laws to establish a lottery in that state. State legislature sends a letter to the Attorney General office some years later saying, I'm introducing a bill to permit poker and blackjack in our state with a license. Can I do that without violating the state constitution? What do you think? Oh, often what you'll see are letters from the Attorney General, and there are several of these, that will tell state legislatures that no, you can't authorize, for example, video poker because it's not a lottery, because you do have some control over the outcome in video poker. You know, if you're dealt 3 aces and you drop 2, that's just foolish. But yeah, you had an influence over the outcome of the bet. But that doesn't mean that video poker has suddenly become a game of skill or not a game of chance. So kind of keep that distinction in mind. Lottery is pure chance. Other games of chance don't necessarily need to be pure chance, but they can still be gambling. This was a big issue when I started teaching back in 2004 and 5. It was 3, because you did have a number of these attorney general opinions coming up. And then you had people arguing that, well, online poker is a game of skill and it's not subject to gambling laws and gambling prohibitions. And here's the attorney general's opinion that says so. And it's really not what it says. What it says is the exemption under the Constitution to allow the legislature to enact a lottery just doesn't include anything that's not a lottery, and that's not a lottery. So we'll cover that again later. It becomes important as we move through the semester. So fundamentally, often what you see with games, particularly games of chance, are these 3 elements: consideration, chance, and prize. So you pay some consideration for the chance or opportunity of winning a prize, usually that's worth more than the consideration you paid. And as we go through that, you kind of see this, sports wagering, you risk something of value upon the outcome of an event that you don't control. Now, is there skill in picking a bet to make on a sporting event? Yeah, there is. But does the sports bettor control the outcome of the event? How many of you follow NFL football? Anybody remember when the Jaguars played the Dolphins? Who would you bet on straight up? Jaguars versus Dolphins. Anybody?
Fins up.
Yeah. Which team do you think is better generally?
The Dolphins.
Yeah. Dolphins are the better team. That would have been the smarter bet. But lo and behold, the Jaguars won that game. And there were several games like that, where the underdog wins, a steep underdog wins. So even though you're making the bet, your skill in making the bet has no influence over the outcome of the event. Same thing with parimutuel wagering. Anybody know anybody that bets on horses? People that bet on horses take it pretty seriously? Yeah. Before I went to law school, I was an engineer for a company called EDS, and I worked with one of the original database administrators for the Army. Back in the 90s when I was young, and this guy was pretty old. He had a computer at home, and the only thing he did with it was analyze horses. That's it. Spent all his free time analyzing horses, writing programs, collecting data about horses for horse racing. And he figured over a 20-year span, he was just shy of breaking even. And that's really, that's all this guy did. I mean, if he wasn't working, he was entering data or collecting data about horses. And when we moved from Fort Sheridan, which was just outside of Chicago, for those of you that know the Chicago area, there's a track there called Arlington. The base we worked on was called Fort Sheridan. That closed, and we were all moved down to Kentucky to Fort Knox, which is right near Churchill Downs. So he was thrilled. But, for all his skill in picking and for all the data he would crunch and the weather information and the track conditions, I guess certain horses run better if it's muddy than other horses when it's dry, things like that. A guy that spent countless hours doing it was just shy of breaking even over 20 years on his bets. So that tells you something. Again, you don't control the outcome of the event. You can make informed decisions about how to bet, but that won't affect the outcome. We'll talk about parimutuel later too. Bookmaking is generally the act of accepting wagers, even on an event of skill, recording wagers, holding stakes, distributing stakes. Let's pull this one up. After I pull it up, I'll switch over. Let's zoom in on this. And we switch the share. All the things we have to do because we're online. All right, bookmaking. Can you see that, or is it too small?
We can see.
Here's one of the definitions. Forwards or pretends to hold or forward any manner whatsoever, a thing or value, staked, bet, or pledged, or to be staked, bet, or pledged, or offered for the purpose of being staked, pledged, or wagers upon the result or purported result of any trial, purported trial, or contest, or purported contest of skill, speed, or endurance of a person or animal, or between persons or animals, or mechanical apparatus. And it's a pretty broad definition of bookmaking. Can you see that? Let me zoom in a little better. So even betting on a game of skill or pledging an amount to be risked on a game of skill is bookmaking. You know, if you're receiving, holding, or forwarding, you know, so this is the, you know, essentially stake holding. 4 is the same thing, but it's with recording or registering. And this is still good law in California. This is the California legislature site. That's the statute. That's bookmaking. And let's go back to slideshow. And it's statutes like that that make it difficult to write clean opinion letters. You'll get in practice if somebody's doing something and they get a new product and they want a clean opinion letter because it's you know, they're going to let other people bet, or they're going to record bets even on a game of skill. And I think you got to tell them, hey, you know, there are bookmaking laws out there that present some risk. The California one, and that one even, you know, if you purport to record it, you know, whether it's for real or not, I think that covers a lot. So let's continue with the basics. Gambling isn't new. And again, for those of you that had this course before, you'll know this. Some research has shown that gambling is an instinct that we have. It's probably not limited to our species. Other primates will gamble. You know, monkeys will take chances to get more juice rather than with the risk that they won't get any, rather than just getting a consistent dispensing of juice in experiments. So they'll take some chances. They'll essentially gamble. And it's been around probably as long as any culture has been around. Archaeological digs show gambling or evidence of gambling in just about every culture. You know, this is a mosaic. I think it was uncovered in Sicily. No, this was uncovered in, I want to say the Umbrian region of Italy. But it shows a dice game in a Roman mosaic. And those dice look pretty similar to dice today. Not a whole lot different. Again, these were Roman dice found in archaeological digs, so a couple thousand years old. It's a backgammon board, and there's some very faint Greek letter writing in there, showing you where to place your bets on the board. You see references to gambling in religious texts, you know, casting lots. Gambling isn't new. The one thing we do have are, you know, from ancient times, a lot of evidence from Roman times. That's just because the Romans left behind a lot of evidence for us to find. You know, they had statutes not unsimilar to ours, regulations not unsimilar to ours, but it was, you know, replicated and survived the dangers of history. The study of gambling isn't all that new. You know, Jerome Cardinal wrote a book in the 16th century about probability. And he wrote the treatise based upon gambling games at the time. So he was analyzing the odds, the likelihood of winning, the different probabilities as, you know, cards came out for different games. Anybody ever played Punto? No. This is a bad analogy, not a great analogy, but it's kind of like the Italian version of poker. It's a card game. Different hands have different rankings and power, and people bet on it. Again, gambling statutes go back at least as far back as Roman times, probably farther back, but we just don't have a whole lot of solid evidence. There's evidence that, gambling was found in ancient Egypt and many Native American cultures, but we don't have real good definitive guidelines for what was going on, what was permitted and what it wasn't. But we do for the Romans, and that's because the Romans left behind a lot of information. So what kind of issues do you think were of concern for Romans? As they wrote gambling laws and statutes and regulations 2,000 years ago. Courtney?
I think maybe even the same as now, that people will just gamble away all their money and then be like destitute.
Yeah, that's one. Lewis?
Yeah, very similar to that, but concentrating more of the sort of upper class members of society.
Yeah, from time to time they did do that. They limited who could gamble. Gavin?
Probably the big one, taxes.
Funny enough, I'm not sure we have. Yeah, I guess taxes would be, but I'm not aware of any specific Roman regulations on taxation. But there most likely was. But the laws that we do have focus on things like fairness, cheating, what games are allowed, what games aren't. We kind of have that today too, don't we? Anybody familiar with 3-Card Monte? It's a traditional scam. Or the shell game. You get 3 shells and a pea or a ball bearing that's under one or a marble. And you can't win that game. We don't permit that even with regulated gaming here. So there are Roman laws on which games you could play and which ones you couldn't for money, which were illegal. There were laws about cheating and penalties for cheating. For sporting events, there were laws about the integrity of the underlying event. And we have similar laws today. In fact, this was a huge issue for the NFL a couple of years ago. Anybody remember the NFL's move to try and collect integrity fees from sportsbooks, legal regulated sportsbooks, but not the illegal ones? So integrity was a huge issue, especially for sporting events. Romans loved horse racing. And they hated anybody that cheated at it. They were passionate about horse racing. Problem gambling and gambling debts were the subject of laws in Roman times. This will come up again. And it changed over time, just like it does in modern society. There were times when all gambling games were prohibited except for wagering on racing. And other times where certain games were permitted and others weren't. Same thing with gambling debts. There were laws that prohibited a certain amount of gambling debt and other laws later that allowed family members to recover gambling debts for losses. So if somebody gambled too much, family member could go in, make a claim to recover the losses. We have laws in certain states today that are like this, where gambling debts are deemed to be unenforceable. Anybody ever work for a casino that ever had issues with collecting credit? Maggie, you? Did it make a difference on where the credit was issued? Yeah,
Not really.
or I should say where the credit was, where you tried to collect the credit from?
I only saw as far as we went to our courts in Clark County.
Yeah. Well, and that's key because gambling debts are enforceable in Nevada. They're not enforceable everywhere. And maybe we should add that to the course. But real briefly, often what you'll have is somebody that's giving credit to go gamble here in Las Vegas. If they're particularly if they're well-to-do, gambling credit is generally a convenience. As Steve Wynn once said, despite his other issues, we like to give credit to people that don't need it. But collection can be an issue. Collecting it in Clark County, very doable. But let's say you have a bettor from Minnesota who's got $200,000 in credit that's out, and the bettor dies. Now there's an estate in Minnesota, and you go to try to make a claim against the estate. Well, in Minnesota, gambling debts are not enforceable. And there are court opinions that say in Minnesota that we can't collect those. It's against public policy. So you need to be careful if you're working for a casino operator where you bring the suit, how you bring the suit. It's a big deal. But again, Romans thought of this. They actually had laws about this. The big things for Roman betting, though, were really racing and athletic combat. Those were the two biggies. At one time, Rome actually had 7 different tracks in the city. It's a lot of tracks. By the way, this is a mosaic showing a Roman horse race. And what you'll notice is that it's head-to-head racing. You didn't have field racing yet. Lewis, you have a question?
No, just more a comment. I was just going to say the highest earning ever athlete was a chariot racer, which I only found out because it came up in a pub quiz. I thought, it'd be like Michael Jordan or someone, but something like 3 billion in today's money or something, which was just crazy.
Yeah, well, chariot racing from Roman times or ancient times or?
Roman chariot racer.
Yeah. Yeah, it was big. It was big business. It was big money. Again, for anybody that has ever been around horse racing, operating a track is an expensive endeavor. And here they had 7 in one city. That's a lot. And I can't think of too many places that have more than one. Chicago used to have a couple. You had Arlington, you had Sportsman's Park. But that was unusual. So 7 in the city of Rome alone was pretty significant. But where the Romans went, the Roman culture went. So throughout North Africa and most of Europe and Asia Minor, Roman culture spread, Roman pastime spread. This is a mosaic from an African bath house where somebody paid to have a mosaic made of a horse or a horse race, basically saying, win or lose, we love you, Polydoxus. Anybody ever do any tiling work? Tiling and mosaic work's not easy. It was expensive then too. Somebody had to really love this horse to spend the time and money to have a mosaic made and to have the phrasing, adhered to the wall of the bathhouse. So really serious stuff. But again, while Roman influence went, expanded throughout Europe and Asia Minor and North Africa, when it receded, a lot of the cultural things stayed behind. And that includes Britain. Britain was Britannia was a Roman province. It was subject to Roman law. And when the Romans left, the inhabitants still were left with a lot of Roman culture, including the culture of betting on horses and betting on athletic combat. And you can see this in tapestries and other historical documents. And in at least in Britain, some of the betting was divided based upon class. So if you were wealthy, you could bet on horse racing and cockfighting and other blood sport. And if you weren't, you could only bet on certain games. And you're probably thinking, Greg, why is this relevant to me taking a federal gaming law class? It's because that history and influences our present day. For example, that Roman law that prohibited the collection of gambling debts and allowed families to recover found its way into British law or English law. In the 1400s, the Statute of Anne adopted basically the same law that the Romans had. Took a while, but it was codified, and it allowed gambling debts to be recovered by family members, and it prohibited the collection of gambling debts. Well, that's all good. But then in 1864, Nevada becomes a state. And you know what Nevada does? And this is in our state constitution. We adopted the laws of England at the time of statehood as the common law of the state of Nevada. So that Roman law that made its way into English law made its way into Nevada law. And right up until the late 1980s, gambling debts were unenforceable in Nevada under common law. So the past really does influence the present. Now again, we changed our laws in Nevada in the 80s, but a lot of states haven't. And a lot of states did the exact same thing. So in a lot of states, gambling debts are unenforceable. The games that were prohibited in the UK were prohibited here. You see this thread going from Roman times into the UK, into the States. So again, until the 80s, late 80s, gambling debts were even unenforceable here. So we talked about the fundamentals. Oops. Let's talk about consideration. You know what? I need to pull up my clock here to make sure I don't go over time. For those of you that are new to the class or new to gaming classes, what do you think consideration is? We talked about consideration, chance, and prize. You've probably had a contracts class at one time, right? If you were like, not so sure. Consideration. What is consideration? Anybody? Courtney?
I think usually in like the gambling sense, you're like giving money for the chance to win. It's something for something else, like an exchange.
Yeah. Alex, what do you think?
Yeah, just to add on to that, sort of like, I guess, the value or like stake that you're personally putting up, like Courtney said, to participate.
Yeah, I guess good ways of saying it. What about like the payment of money? Consideration? Yeah, that's classic. What about the forfeiture of property? Buffalo Bills fan, I'll put up my car. Josh Allen's gonna kill him. Oops. This kid was arrested out Chevy. What about the forfeiture of an opportunity? I could have gone there, but I'll come over here and visit your store so that I can participate and a prize contest. A drawing. Change in position, a promise. What about substantial effort? Think of substantial effort. We'll enter you into our drawing, but you've got to do X, Y, Z. You know, I had a client once that was a touting site, and they offered to place a bet for me instead of paying me after I wrote an opinion letter for them. Like, no. That took substantial effort. No. Minimal effort. So to enter this contest drawing, you've got to put your name on a postcard. You got to type in your email address. What do you think? And generally not. And I think most people don't see that as consideration. I mean, how many of you have entered a contest where you had to type in your email address? Do you think of that as consideration? Or is it just, you know, sort of some minimum effort you need to do to participate? Yeah, it's, you know, some minimum effort, but what about benefit to a promoter? And we'll see that. Benefit to a third party, benefit to any third party. There was a, her name escapes me. Anybody remember the Hanging Chad's Secretary of State from Florida? Well, at one time in the early 2000s, the Secretary of State in Florida that made the call on the presidential election eventually became issued a letter regarding contests in Florida. Now, at the time, all contests in Florida were regulated by the Secretary of State, and her letter basically said all online contests are illegal in Florida. If it's on the internet, it's illegal. Why? Because the internet's not free. Somebody somewhere is getting paid for that internet access. So if you go online at a library and you enter a contest, you know, I'm sure ESPN's running a dozen of them. There's probably several running for the Super Bowl right now. Those are all illegal in Florida. So she issues that letter. Anybody know of any big businesses with interests in Florida that run contests on a regular basis?
Disney.
Yeah, Disney. Anheuser-Busch. They weren't too thrilled. So the legislature took contests and moved it into the Department of Agriculture, who quickly issued a letter saying, ignore that letter from our Secretary of State. And then after she was out of office, they moved it back to the Secretary of State's office. But, you know, that was her argument. You know, if there's a prize and it's given away from a drawing, then we're going to find that, you know, you have chance and prize, and if it's online, there's consideration because the internet's not free, computers aren't free. Somebody made money somewhere, but I think she missed the boat on that. Cud v. Ashenburner is a good case. Anybody remember the facts of this one? It's a good one because it's relatively short and it gets right to the point for the most part. And if anybody's ever shopped in a grocery store, you've probably seen something similar. Anybody ever see one of these grocery store contests? Yeah. And I've seen them here. Is it Vaughn's that runs one every year with Monopoly theme? You know, town I grew up in, every grocery store would do these things periodically. You know, you have a random drawing. You fill out a form. And you get a coupon with numbers on the edge. Today, it's probably not so much numbers on the edge. But you fill out a form, you fill out a ticket, it goes into a hopper, and then once a week, there's a drawing. But you have to be present to win, because they give away the prize right then and there. But you don't have to actually purchase anything from the store. You can walk in, get your playing piece or fill out your ticket and leave. Right? Not that complicated, pretty easy to understand. Anybody? Any confusion there? No? Yes? It's okay. Just getting started. So anyway, the grocery store does get sued. And, you know, what are the arguments that this is a gambling event? Clearly it got to the point of a court opinion. Somebody had to argue that it was a gambling event. So we can eliminate those last two elements, right? We know there's a prize. We know it's a random drawing. So you've got chance and prize. So what would you need to make it a gambling event?
Consideration.
Yeah. Yeah, right there at the top of the slide. Consideration. So what is the argument that this scheme has consideration? Even if you didn't read the court opinion, knowing what you know now, just off the slides, what's an argument you can make that this is consideration? Courtney.
You could say that like you have to give your time because you have to be present to win.
Absolutely. Got to be present to win. Got to fill out that form or the ticket. You know, there's some effort there. You have to be at a certain place at a certain time. So you're foregoing other opportunities. What's the argument that it's not gambling? Or that there's no consideration? So again, we have the other two elements. All we have to do is focus on consideration. Lewis.
The customers didn't have to part with anything, and even if some of them did, you know, buy groceries while they were there, it wasn't essential to be considered for the draw.
That's exactly it. I mean, it doesn't cost you anything to play. You don't have to purchase anything. You don't have to part with anything of value. Therefore, there's no consideration. That's how the court decide the issue. Oh, Alex.
I was going to mention a little part that I remember in the opinion that was really funny was it was talking about groceries, like the concept or idea like that people are either going to, like it's either, okay, you're just buying groceries, but then like it further is like, oh, but wait, what if you buy more groceries, you know?
Yeah.
You're really going in there to, you know, get this drawing.
Buying more groceries won't help you, right?
Yeah.
Sorry, I didn't see the hand thing because you get kind of a light background there.
No
Blended in on my screen, but no, you're right. You know. So what did the court decide on this one? Well, court said no. You need all three elements: consideration, chance, and prize. You've got chance and prize, but to meet the element of consideration, participants have to part with something of value. And in this instance, nobody's parting with anything of value. Merely filling out a ticket isn't imparting value to anybody. Having to be on site when the drawing occurs, again, isn't really imparting value. Therefore, there's no consideration. And this is kind of called the valuable consideration theory, that for consideration to be present in the gambling event, participants, the players, have to part with something of marketable value. There's no marketable value for just showing up at a store. Nobody pays you just to show up. Mr. Price.
Could you argue that there's marketable value when you're giving personally identifiable data, privacy sort of as currency?
Yeah, you could. And it's been argued. And a lot of it depends on how much you're giving. You know, if it's just your email address or your contact information, that's the information you need to be contacted to say, hey, you've got a prize. The other counter argument to that is that one email address, one phone number is not worth that much. It's something to the right of a penny. You know, when these lists get sold, it'll be, 200,000 names for $1,000, right? And any individual name just isn't worth that much. So, but here, and the other thing is that as you do that, does it cost you anything? Are you out of pocket anything to give somebody your email address? Probably not. So at least in Oregon, with this opinion, you need to have all three elements present. And the consideration element is determined by whether something of marketable value is transferred from the participant to the promoter as a requirement of being entered into the contest. And again, there was that argument that, well, you're buying groceries, that's consideration. Well, it's not. It's consideration for the groceries that you're buying. Whether the contest was going on or not, a jar of peanut butter is going to cost you the same amount. And on top of that, you're walking home with a jar of peanut butter. You're getting what you paid for. And this is the prevailing view or the prevailing theory of consideration. It's this valuable consideration theory. Well, let's move on to the next one. The Seattle Times case. Anybody ever have a contest like this in your hometown, or if you're not from around here, where newspaper, when I was growing up, we had this in the newspaper in the small town I grew up in. We had a football picking contest. And each week you would pick who you thought the winner was going to be for each game. And then there was a tiebreaker for Monday Night Football with scores. And whoever got the closest to the score in the event you needed a tiebreaker would be declared the winner for that week. And there were some small prizes. Usually it was like a plate, with some, the name of a company that was sponsoring or an advertiser to the paper. But each week you do this. And at the end of the year, the person that had the most number of wins and had the best picking average for Monday Night Football actually won a cash prize. Wasn't huge, $150, but I can tell you as a kid, we'd sit there on Tuesday. I think the cutout thing there would come out on Tuesday, and I think you had to submit it by Thursday. These were popular back when newspapers were popular. Anybody still get a newspaper? One, maybe two people. Nobody. If I'd have asked this question 20 years ago, most hands would have gone up. But this is what's going on in Seattle. So the Seattle Times sponsors this contest called the Guest Guesser, and you fill out the form and you just pick the winners for NFL football each week. And again, you have that Monday night tiebreaker, and you don't even have to buy the paper. You can give them a facsimile of the entry form. Now, they would not take duplicates like off of a duplicating machine or carbon. But again, this is 1970. You probably don't know this, but mimeograph machines and carbon paper at that time were kind of filthy. I don't think anybody here is old enough to remember. They used to come out like on purple ink, but the ink would smear. So, and the same thing with carbon paper. If you use carbon, anybody ever use carbon paper? Yeah, carbon paper is kind of messy. You know, it leaves dust and you know, marking carbon everywhere. So you could do it, but you had to hand draw it and you could enter it as well. So you didn't have to buy the paper. But you can enter each week anyway. Now the operative law for this one is that the state constitution prohibits lotteries and the city ordinance prohibits lotteries and the state statutes prohibit lotteries, but lotteries under the state statute are defined as a scheme for the distribution of money or property by chance among persons who have paid or agreed to pay a valuable consideration for the chance, whether it's called a lottery, a raffle, a gift enterprise, or by any other name. So everybody understand the contest? So what's the argument that it is gambling? Again, we have prize, no question. Chance, even though there's, you know, some skill in picking games, there's no skill in determining the outcome. So chance is there. The only issue is consideration. What do you think? Courtney?
Yeah, like you have to follow the teams and fill out the form and mail in the form, and that takes time, but I think it's again like minimal.
Yeah, that's one of the arguments. It takes some time to fill these things out. You got to think about it. You know, if Chiefs are playing the Jaguars, oh my God, you know, that could take you hours to figure out. Again, you're not picking against the spread, you're just picking a winner. You know, the truth is that 80% of the games are pretty easy to pick. You're just picking a winner. But that's the argument. You got to put some time and effort, you know. What's the argument that it's not gambling? Or there's no consideration? Nobody? Oh, Alex.
I don't think that they had to actually pay to enter when they mailed in the little coupon clip. I think it was just the little entry from the magazine, which you still had to buy a magazine, but or a newspaper. I mean,
Yeah, I mean, the argument is that you don't actually have to, you don't even have to buy the newspaper. You can just write it on a piece of paper and send it in, as long as the paper's the right size. Now, again, the right size isn't to make it difficult on people entering. It's to make it easier for the people that have to tally this stuff up. You know, Seattle's a pretty big town. You know, if you got thousands of entries and they're all different size paper, you know, the intern or the clerk that has to go through that, it's kind of a cruel task. But if everything's about the same size, fine. And that's the argument. It's not gambling. I mean, it's just like Cud v. Ashenburner, right? You're not parting with anything of value. You don't have to pay to play. If you want to buy the paper, you can. There's no evidence that subscriptions went up during the contest time. So what does the court say? Oh, court says, yeah, that effort, boy, you know, that effort creates enough consideration to create a contract. If there's enough to create a contract, a binding agreement, that's enough to find the consideration element. Having found the consideration element, knowing that there's a prize, knowing you can't control the outcome of the event, we have a gambling event. And that's called the contract theory of consideration. That court opinion is still good law, although there are conflicting court opinions on that, even out of Washington. But Washington State has some really interesting court opinions, even up until recently, about consideration for gambling events. And we'll talk about that when we get to social gaming or social games. So now you've got the valuable consideration in CUD. You've got this contract consideration coming out of Seattle Times. Let's move on to one more. Troy versus Attenweiler. Anybody remember this one? I'll just put the facts up. By the way, these promotions were really popular in the 20s, 30s, 40s, and 50s. I haven't seen too many of these since. These are called bank nights. What a bank night is it's a contest designed to bring people generally into theaters, movie theaters, playhouses, things like that. And what it does is it allows anybody to sign up for the drawing. You go to the theater, you can sign up for the drawing, and then the drawing is held, and the winner has a limited amount of time to claim the prize, usually a couple of minutes. So if you're in the theater, it's pretty easy because they make the announcement on the theater stage. And then after they make the announcement there, they make the announcement outside so that those that played for free can claim the prize as well. But they have to come up to the stage to claim it. And that's exactly what happens with this contest. So theater owner has a double feature. In order to generate more people coming for the double feature, they run a bank night. What you'll see again, particularly during the Depression in the 30s, is that these were really popular to generate more people attending the theater, movie theater. And they would give away things like a little bit of cash or a brand new suit, something like that. And that's what happened here. Now, again, there's no charge to enter. So what's the issue for the court? Well, we know there's a prize, right? Cash prize, in this case. We know there's chance because it's a random drawing. You know, the tickets go in a drum. So the question is there consideration? What's the argument that there is? Lewis.
I think this was relevant to this case, but wasn't the argument made that without this, the theatre would lose a lot of business, so it sort of relied on this for promotion?
Yeah. What's the argument that it's not gambling? I guess we probably should have started there. Think 2 cases ago. What's the argument that it's not gambling? Courtney.
Yeah, that you don't have to pay to participate.
Exactly. You don't have to pay to play. As Lewis said, the argument for gambling is that, the theater owner testified, if you take away the contest, I'll lose thousands of dollars in people coming to the movie theater. So, the promoter is getting some benefit from this. That's kind of what the court focuses on. The plaintiff asserted that if they can't run the scheme, they'll be out thousands of dollars. And the court says, whose thousands of dollars will they be out? But the participants. They're getting increased patronage, increased benefit, and therefore the consideration element is met. So we call this promoter benefit theory. The promoter gets some benefit from the contest, and consideration will be found. This is still good law in some places. It's not the prevailing theory, but we do have these three theories. So again, valuable consideration, that's the one that most states, most courts use. It's the one, if you're seeing federal court opinions, that they'll primarily use, the valuable consideration theory. Parting of something of more marketable value, usually money. Contract consideration, like Seattle Times. Consideration sufficient to create a binding agreement or obligation. You know, at Seattle Times, that effort you needed to put in to play the game was sufficient consideration to create a binding agreement. Therefore, under contract consideration theory, we have consideration for the gambling event. And then you have promoter benefit. Promoter benefit, this is a good example. This is still good law in the state of Wisconsin. You can look it up. 945 5B1. It's in the definition of prohibited lotteries. And here it says, consideration in this subsection means anything which is a commercial or financial advantage to the promoter or disadvantage to any participant, but does not include any advantage to the promoter or disadvantage to any participant caused when a participant learns from newspapers, magazines, periodicals, radio or television, where to send the participant's name and address to the promoter. So looking at this, I understand financial advantage, but what's a commercial advantage that isn't a financial advantage? What do you think?
Information asymmetry.
Yeah, information you send, maybe. What do you think? Any other thoughts on this? No? Lewis?
Maybe like reputation.
Yeah, absolutely. Reputation, goodwill, marketplace recognition. In theory, all those could be a commercial advantage. And again, this is still on the books in some states. Wisconsin, I just use this one because it's pretty short and easy to read. And because you have that commercial or financial phrase in there, which I find interesting. You know, are there any contests that a promoter runs that don't give them some commercial or financial advantage? Probably not. Anybody ever take a business law course? Oh, Courtney.
Oh, I was just gonna say, like, even like a charity benefit or something could be like a commercial advantage because it makes you look like you're, doing this great charitable thing.
Yeah, in some places, I think you're right. Anybody ever take a business law course? Formation of companies, corporate documents. Usually somewhere in there, you're going to have the purpose of the company. So Mr. Price, what do you usually put in that spot? What's the purpose of most companies?
Making money.
Right. It's their commercial ventures by nature. We'll talk about this when we talk about First Amendment and commercial speech. But the sole purpose of most businesses is to make money. It's to be a commercial venture. So, promoter benefit, you're only doing it for commercial advantage of some sort. So in those states, there's always a risk that you've got a gambling event. So if you take consideration out of the equation, so you have no consideration but chance and a prize, what do you have? What would you call that? Anybody ever see an event like that? Lewis?
So sweepstake.
Yeah, exactly. You see that all the time. I mean, there are hundreds of sweepstakes running right now in the United States, maybe thousands. You know, I bet you could find one for this, you know, to win Super Bowl tickets. You know, hotels run these all the time. ESPN runs them a lot. McDonald's does it with their Monopoly contest each year. You know, they're all over the place.
I saw on the news yesterday, Red Cross is doing Super Bowl tickets.
Yeah,
But
there you go.
you got to donate blood though, so I don't know what the consideration, you know.
Yeah, does blood have value? Yeah, probably.
Shakespeare's Pound of Flesh.
Yeah.
Yeah.
Yeah, I mean, I don't see any law enforcement going after the Red Cross for that, but yeah. Well, we saw this, you know, with, you know, about a year ago when the vaccines were readily available. You had some states offering contests. If you got vaccinated, your name would be entered into a drawing. And I think Michigan did this, and Ohio had a big one. Ohio had like $1 million prize. It was state sponsored, but probably not commercials. The government of Ohio is probably not a commercial venture. At least if it is, it's not a very successful one. But yeah, I mean, using promoter benefit theory, just about all of those sweepstakes then become gambling events. So if you're ever tasked with writing an opinion for somebody that's running sweepstakes, a contest, I mean, I think UFC does this on a regular basis. NFL does this periodically. You know, they'll run contests. Video game companies will do this. But if you're writing a letter on it, you got to let them know that, yeah, there's some risk. You still have contract consideration law out there in some places. You have court opinions that use contract consideration. And if you've got a binding set of rules, that's probably enough. And, you know, what contest promoter doesn't want the rules to be binding? That's why you put the rules out there, because you want them to be binding. You know, in those rules, you'll see things like, you know, the participant has to pay for the taxes on any prizes, you know, things like that. Alex.
Speaking about sweepstakes, are sweepstakes allowed, since like sometimes based on, you know, the consideration theories, allowed in states like Utah or Hawaii?
Yeah. Yeah, what you used to see when I was growing up, Wisconsin, I grew up in Wisconsin, we had that promoter benefit law, still have it. And you'd see exceptions for Wisconsin. So, you know, I lived near the Illinois border in Wisconsin. So you'd have to cross the border to play contests. You want to do the McDonald's Monopoly, you had to go to the McDonald's in Winthrop Harbor, Illinois, which is right across the border. But then at some point, they just stopped doing that. So if you look at a contest today, let's do that. Let me see if I can bring up the contest. And then we'll have a couple of hypos. Oh, let's see. Travel Channel. Yeah, we're here. We're here. People Magazine. Dress like a celebrity. Let's take a look at that. This is always dangerous because I've never looked at the rules before, but I got a pretty good idea what's in them. So People Magazine's running a $15,000 sweepstakes. Dress like a celebrity. Enter for a chance to win a celebrity wardrobe makeover, whatever that is. Official rules. Void outside the United 50 states. So you have to be a legal resident of one of the 50 states. Notice, Wisconsin's not exempted. Washington State. People in Seattle are not exempted.
I don't like the void where prohibited language.
Yeah, I don't think that does much for you. You better put it in there if you're doing somebody's rules, but you know, and you'll see this in just about every sweepstakes rules these days. And it's just that we just haven't seen any enforcement of anything but valuable consideration, probably in the last 30 years, with more, maybe one exception, one exception, but it's an odd one out of Washington State. So again, you're eligible in all 50 states. You know, eligibility. This sweepstakes is open to legal residents of 50 states in the District of Columbia, 21 years of age or older. You know, there are certain people that can't play. You know, if you're not, you know, you can't be an employee or an immediate family member of an employee, or household member of an employee. So this is pretty common. And yet, you think they want this to be binding? Oh, sure. Because they want you to sign a DocuSign release of liability and publicity. Lewis, question.
Not so much a question. I was just thinking about last year back in the UK when everyone was, you know, desperate to get vaccinated, but you know, we were told that we had to wait like ages until we could get it, and then you'd see news stories from over here in the States being like people getting vaccinated in Kentucky are put in with a chance to win like an SUV.
Yes.
We would just say, you know, it's absolutely crazy. You know, when back home we were talking about like, yeah, we paid to be able to get vaxxed, and they're like giving away cars and stuff and Xboxes. Like it was just bizarre.
Yeah, well, I mean, you're here, you can see the differences of opinion on vaccines and some of the crazy logic that's out there. Anybody see the latest one where some pundit was claiming that drinking urine would keep you safe from? How many a few of you saw that? I don't know. Oh, you know, I'd like to say only here, but it's not only here. You see this kind of crap everywhere. But yeah, it's nuts. But today, again, valuable consideration theory is really the key. That's the one you got to kind of look for. If you're doing letters, though, as an attorney, and somebody has a sweepstakes, they want a letter on it, you got to let them know about those other two theories of consideration. And then it presents some risk in some states. And as we'll learn, if you have risks in some states, you're going to have federal risks as well. So let's go to hypos. I think somebody asked for hypos. So again, RevGame is an online gaming streaming site with head-to-head gaming content. To support it, they're currently using an ad-based revenue model with ads in the borders of the streams, but they want to offer a poker tournament with cash prize as a promotion to get more users. But to fund that, they have three options. You know, continue with the ad-based revenue shown during gameplay. Have a nominal fee, you know, $1 or $2 from each player, or have ad-based revenue from contestants. In order to play, you have to go watch, you know, 3 or 4 videos. Once you watch that 4th video, you're going to get a code. Once you have the code, you can enter. So what do you think? What about option 1? What are the risks? So we can eliminate those other two elements, right? You know, there's gonna be a prize, it says cash prize right here. Let's see if I can't highlight on here. Let's go back. And poker. Poker is a traditional chance game. Despite arguments to the contrary, it's a chance game. So the issue is consideration. Is there consideration with that first model? Ad-based revenue for ads showed during gameplay on the border of the stream.
I'd say less so than the other two.
So, you know, which theory would that be?
Would it be playing? Would the ads be playing whilst you're involved in the game?
Yeah, so we're playing a game. You're playing in a poker tournament. At the bottom, there's a scrolling thing, and you know there are ads that pop up. You know, Pepsi. You know, go to, you know, sign up for Match.com. Sign up for whatever, and the ads just kind of scroll at the bottom. Then the site makes money off of ad revenue. Courtney, what do you think?
I think even though those companies aren't like the promoters of the event, I think it still would be under the promoter benefit model of the three.
Yeah, I mean, I think in this one, there might be a little risk under promoter benefit or even contract consideration. What about under valuable consideration theory?
Maybe because the companies are paying to have their ads run, and then people that are involved in the gaming are seeing those ads.
Yeah, but you know, I would say under valuable consideration theory, are the people that are playing in the tournament required to part with anything of value?
No.
You have to pay to play? No. So I think it's a pretty low risk endeavor. You know, for the site to do this, yeah, promoter benefit probably. Contract consideration, well, that applies to everything. So there are those two risks, but really not under valuable consideration theory. And that's your primary issue. I mean, you're going to run the same risks that People Magazine is running with their dress like a celebrity, right? So if they're comfortable with that risk, being like People or McDonald's or Coca-Cola or Disney, they're probably okay. But there's a risk. What about the nominal fee? What do you think? Number two.
Red flags.
Yeah. Got to pay to play, right? Clear, you know, if you're paying to play poker to win cash prizes, how's that any different than walking into a casino and paying to play? You want to think just couch it? Well, it's only $1 for administrative fees. Does it matter? No, because you're looking at it from the perspective of the player. Is the player parting with anything of value? Regardless of where that money's going, do they have to pay to play? And in number two, they do. What about number three?
So as opposed to like number one,
Yeah.
where you're playing the game and it's going on in the background, you're not like parting with your time. Whereas for number three, you'd have to actively be doing something that you wouldn't be doing normally.
Right.
So I think there is an argument to be made for parting with some consideration.
Yeah. Anybody ever see anything like this?
You're kind of rendering a service.
Yeah, because the site gets paid on per eyeball views. So they're going to make you watch 3 ads or 4 ads. Each one's going to be 30 seconds to a minute. And then you get a code at the end, and then you can play using that code. This is becoming more popular because it's a way of getting direct funding for the site. but I think you're getting a lot closer to valuable consideration at this point. I think there's a risk. You know, it's back to that change in position or substantial effort. You know, if it's really short, you know, you put an ad in front of the sign up page. Anybody ever watch a video that, you know, from a news site and they put a couple ads in front and then, or YouTube if you don't have a subscription, right? Now YouTube doesn't offer any prizes, but you know, same kind of idea. I think if it's short enough, the risk is low, but you can start seeing where this gets into kind of a sliding scale. You know, maybe 10-second ad's no big deal. But if you're tying somebody up for 4 or 5 minutes and making money off of tying them up for that, I think there's a risk, a significant risk. I think at that point, maybe them watching the ads really is valuable. Is their time worth anything? Now you could argue that playing poker, you know, is time, but you know, that's an endeavor people like to do. Nobody likes to watch ads. Well, maybe after the Super Bowl just to see what the crazy ads are, but normally, no. Do you really want to see a mortgage broker's ad? Or an extended car warranty ad? Probably not. So again, you know, a couple of hypotheticals. By the way, I've had questions on all three of these recently. Here's another one. Ezra picks calls. You know, they've got a touting site. Everybody know what a touting site is? I'll show you a video next time. It's where you sell picks to sporting events. You know, I've got a lock pick this week. Call 1-900-LOCK-PICK, you know. And it's a business whose reputation is somewhere south of used car dealer. It's high pressure sales. You know, more often than not, these experts aren't any better at picking than you, me, or flipping a coin. So, but it's big business. So they want to get more traffic. They're relatively new, and they want a contest where they pit anybody in the contest against the AI that they use to create their picks. Contestant with the highest score that's better than their AI wins a cash prize. They want the cash prize to equal 80% of the entry fees. So they'll keep 20% to administer the site. Is that an issue? Well, if you've got entry fees, people are paying to play. So yeah, it's an issue.